Mr. Simpson.
Thank you, Lord. For the rest of my submissions, I will first have a brief look at the legislation, second, the facts, including the FTT's decision, and then some of the documentary evidence to which my friend referred. And finally, I'll look at some of the case law. Legislation starts at page 782 with section 417 of ITIPA, section 417, subsection 1. One can see there that the focus on this part, that's to say part 7 of the 2003 Act, is where securities, interest in securities, or securities options are inquired in connection with an employment. So the focus is, in my submission, on matters connected to employment. One brief point about the definition of securities option in section 787, in page 787, section 420, subsection 8. 420 subsection 8, about halfway down page 787. Well, securities options means a right to acquire securities other than a right to acquire securities which is acquired pursuant to a right to opportunity concerned with avoidance of tax and national insurance contributions. First point, the footnote 13 directs us, so far as that amendment is concerned, to section 92, subsection 5. The Finance Act 2006, that provides that the amendment applies for options granted on or after the 2nd of December 2004. 2nd of December 2004. So that's the date, the relevant date for that provision, retrospective, it seems. Second point, and this is a theme that I suppose runs through the case.
Just before we leave that, I mean, the words that we see in parentheses there, do you know why they were introduced? Is that an attempt to reflect price, or?
That's my understanding, Lord, but that's just from background reading as opposed to absolute to actual knowledge of the purpose of it. So a securities option is a right to acquire securities. Throughout these submissions, of course, we're not talking about the right to acquire the securities, the option itself, but the right or opportunity to acquire the right to acquire securities. So if my language slips from time to time, just because it is a bit of a mouthful, the focus in my submission is always on not the option agreement itself, but on something that preceded the option agreement being a right or opportunity to enter into it.
Does that make any difference, that point, for the purpose of this case?
In my submission, it's reflected in my submission that one isn't looking at simply the grantor, who granted it.
Right.
Because the grantor obviously is the person who confers the right, the securities option. But what the provisions are looking at is something before that. Where does, in this case, Mr. Noble specifically, get a right or opportunity to enter the replacement option agreement?
Thank you.
Section 471 appears on page 792. One brief point in subsection 1. The text is, this chapter applies to securities option acquired by a person where the right or opportunity to acquire the securities option is available by reason of unemployment of that person and so on. It may not make much of a difference, but in HMRC's written case, they repeatedly refer to the text being is made available. That's not what the text is. The text in subsection 1 is simply the right or opportunity to acquire the securities option is available by reason of unemployment of that person or any other person. I say that may or may not make a difference. If it does make any difference, my submission is that the actual wording allows, or more obviously allows, a scenario for a right or opportunity to become available otherwise than someone making it available.
How can something be available unless someone or something has made it available?
Well, that would...
I mean, unless you're able to point to a context where made available would have a different meaning from available, I'm not sure there's much in this.
Well, indeed, well, that's why I say it may not make a difference. It might be, for example, in the present case, that if one could regard Mr. Noble's right opportunity as being available simply because he held the original option, and it wasn't made available by anyone in particular. His right opportunity to acquire the replacement option was available by reason of his holding, of the original option.
But if, as I understand, you are accepting that the 2007 option, or the right to the 2007 option is an opportunity that was made available to him, the focus of your attack is on the latter part of subsection 1, namely available by reason of the employment.
Yes.
And whether it's made available by reason of the employment or is available by the reason of employment will make, I would have thought, not a blind bit of difference.
Yes, indeed, more. So ultimately, it probably doesn't make any difference. But just to be clear, the text is as I've set out. Subsection 2, for the purpose of subsection 1, employment. For the purpose of subsection 1, employment includes a former or prospective employment. It's curious that it applies, or notable that it applies only for the purpose of subsection 1, because in subsection 3 is the one that, or one of the ones that we're looking at here, and I needn't take the court to that. I've got nothing in particular to add to the text of, or to comment on the text of subsection.
Well, but the phrase "by reason of an employment" in subsection 3 must mean the same as "by reason of an employment" in subsection 1.
Well, indeed, my lady, so I'm not pressing that point particularly hard. It's just a notable audit.
Well, it says in section 3, it says for the purposes of subsection 1, so
yes.
That also must mean that employment in 3 refers to former and prospective employment.
Yes.
Anyway, that's I think all I have to say about the text of those provisions. Now I'm looking to the facts, and in particular some of the findings of fact of the first-year tribunal. I start on page 150.
Sorry, page?
Page 150, paragraph 7 of the tribunal's decision. And that is where the tribunal finds that Mr. Noble and Mr. MacDonald, having been a partner in Dixon Minto at the time of the two transactions, were called as witnesses. The tribunal found them both to be credible and reliable and adopted their evidence as to matters of fact. So, for the avoidance of doubt, where the tribunal, in the course of its narrative of the facts, refer or quotes from parts of their evidence. My submission is the tribunal is adopting those quotes as findings in fact.
Yes, well, I mean, given that finding of credibility, when they refer to the witness's evidence, that must be right. Unless the tribunal were to qualify it in any way.
Yes, of course, my Lord, of course. I turn next to paragraph 49, which is at page 158. Paragraph 49 at page 158. And here, without qualification, the tribunal quotes from Mr. MacDonald's witness statement setting out the reasons why no variation, why the mechanism chosen was not variation, but was instead cancellation and a grant of new options. Variation agreements weren't entered into as there was considerable time and financial pressure to complete the 07 refinancing, as wages required to be funded, and having 2 documents rather than 4 was seen as simpler. Already a considerable number of documents given the significant amendments, and the transaction Bible is bulky, and again there was considerable pressure on fees. The consideration for the 07 option was effectively the cancellation of the prior options which had been granted in 06. So in my submission, it's quite plain that the reason for the choice of mechanism was not anything substantive, but was simply, it was regarded as the more convenient mechanism to achieve the same effect. That being so, in my submission, that in itself is enough to vouch the proposition that the grant of the new options or the replacement options wasn't by reason of employment, but simply because of a choice of mechanism as to how a particular end should be achieved. For what it may be worth, it's not referred to in the tribunal's findings in fact, but Mr. Noble mentions this in his witness statement as well, page 213.
Are we allowed to refer to things that are outside the findings of fact of the first-tier tribunal?
In my submission, my Lord, in this case, yes, because the first tier adopted Mr. Noble's evidence as findings in fact.
And no, they didn't. They held that Mr. Noble and Mr. Kevin MacDonald were credible, and then made findings of fact based on their evidence.
Well,
anyway,
I didn't go into that.
You can show us the passage.
Yeah, well, it simply supports what Mr. MacDonald says. It's maybe not necessary. Page 213, paragraph 7. In the middle of that paragraph, it simply says that rather than dilute the existing option, the mechanism chosen by the company's legal advisors was to cancel the existing option and reinstate it as a new 1.5% option with exactly the same rights and terms. Now, of course, it's not quite the same rights and terms, but at least so far as the explanation for why that mechanism was chosen, in my submission, it's consistent with what Mr. MacDonald said.
Well, not the final sentence, it isn't.
No, indeed.
It was, in effect, the same option, but now 1.5% rather than 2.5%. That is simply incorrect.
Yes, because of the extended
Because of the extended
yes.
period, yeah.
I return to the first tier's decision. Paragraph 104 at page 172.
Paragraph?
104.
104.
Page 172.
Yes.
As my Lord Hodge pointed out, Vermilion and Friends submissions, in a sense, this is not a finding of fact because it supposes a hypothetical question. If Mr. Carnegie had asked, what would have been the answer? And that question was not asked, and that answer was not given. But, my lords and my lady, I submit it does contain a finding of fact because it is the means by which the tribunal has expressed the answer to the question, why, as a matter of fact, did Mr. Noble get the option? And the fact that the tribunal finds is that he got the option because he had the 2006 option, which has to be diluted to become the 2007 option. The tribunal then goes on to, in effect, repeat this, or explain why, again, what the reason was in paragraph 105, as a matter of fact. So as a matter of fact are the opening words of that.
Well, it isn't a matter of fact, though, is it? It involves an evaluation.
It involves an evaluation of at least factual causation.
Well, on your case, it's not purely factual causation because it's not a pure but-for test. So then, amongst all the possible but-for pre-existing events, you have to pick out which reach the status of being causes, and that involves an evaluative judgment.
Indeed, in a sense, any time one identifies anything as a factual, as a cause, as a matter of fact, it's a slightly pointless exercise because everything is connected with everything else, as one hears in various different contexts these days. But at least my submission is that first, it is at least the finding that, as a matter of fact, the cause, the use of causes, are unusual.
That's what makes it rather difficult to say it was a finding of fact, because causa instantly makes you think of the Latin causa causans or causa sine qua non, and the learned tribunal judge goes on to apply the latter but-for test 3 lines further down.
Yes, well, without the respect to supplier options, neither Mr. Noble nor Dixon Minto would have been granted by the nominee companies the right to the 07 options.
That may well be so.
Indeed. So,
what does it tell us? It tells us that in the creation of the corporate rescue, Mr. Noble and Dixon Minto had a negotiating position.
Indeed, in the context of the corporate rescue, vis-à-vis the company and the consortium investors, and that negotiating position came about because of their existing options. It did not come about because Mr. Noble was appointed or agreed to be appointed as a director. And my submission.
Do you say that the First State Tribunal judge was finding that, as a matter of fact, Mr. Noble's directorship was not a but-for cause, or was not a causa sine qua non? Or is the finding that it's not an operative cause, if you like?
Well, my submission is the implication must be that, sorry?
It could be, I accept it, well, I can see it could be a matter of fact if the First Tier Tribunal is saying, well, I find it's not the case that the option would not have been granted if Mr. Noble had not been the director.
Yes, well, my submission is that at least the implication is that, as a matter of fact, all of the at least the main factual cause, the real factual cause, was what is set out here, and in particular, the implication is that the appointment as a director was not was not the reason for the grant of the new options.
Paragraph 105 seems to be proceeding on the basis that you're concentrating on a single cause, single causa. It refers to, in the first line, was not the causa of the grant of the 2007 option.
Well, that might be the case, my lord, but one has to recall that in paragraph 102, just before that, the tribunal has quoted the passage from Master of the Rolls and Wixon Firth, where the Master of the Rolls expressly says it must simply be, so I'm going to age for I need bifocals.
Yes.
The fact of employment must be one of the causes for the benefit being provided, but it need not be the sole cause or even the dominant cause. It's sufficient that employment was an operative cause in the sense that it was a condition of the benefit being granted.
The upper tribunal judge took the view that the learned judge in the first tier tribunal had proceeded on the incorrect basis that there was a reference to one cause. And I thought it was common ground between the parties that it's enough that it could be one of a number of causes.
Yes, it must be one of a number of operative causes, or in some sense a real cause. My submission is that a causa sine qua non test is not enough. It may be that the idea of causa causans is the right one. It may be something slightly short of causa causans, in the sense that if I have a job, if I have an employment, and I get paid, the causa causans of getting paid is doing the work. It's not having the contract of employment. If I don't do the work, I don't get paid. So we might have to look a bit, widen the net a bit from the idea of causa causans to get to by reason of employment.
I think the point being put to you by my Lord Legate is that one crosses a line from fact to something different, i.e. evaluation of the fact, if one is no longer applying but for causation test. So long as one is saying that it's something narrower than that, you are outside the realm of fact that this court can't go behind. And as I understand it, your submission in relation to paragraph 105 is that that isn't purely dealing with but-for causation, and therefore it would be open to us not to agree what was the cause.
Well, my lord, I would submit that there must be some sort of area in which a factual judgment can be brought to bring short of but-for causation. Because if one were ever talking about purely facts in terms of but-for causation, the inquiry would never end. It wouldn't be possible to say that as a matter of fact anything caused anything. So my submission here, what the tribunal says is that as a matter of fact, the cause, the causa, was X. And yes, that does inevitably bring some judgment beyond merely a but-for test, albeit that there are echoes of the but-for test in the second sentence. Without the respective supplier options, neither Mr. Noble nor Dixon Minter would have been granted the right to the 07 options.
It says that, but they don't say, or she doesn't say, that the grant, the 2007 option would have been granted even if Mr. Noble had not been the director.
No, she doesn't say that, but in my submission, if that had been the tribunal's view, the tribunal, or if the tribunal's view had been that but for the appointment as director, the 07 option would not have been granted, the tribunal would have said that here, because here the tribunal says, in effect, but for the original options, there would have been no replacement options.
She seems in 104 to be identifying another director, Mr. Carnegie,
Yes,
who did not get an option,
that's right.
and regarding that as establishing that the reason why Mr. Noble did get an option couldn't be because he was a director, so it couldn't be by reason of his employment. But there are lots of share schemes in which some employees, but not others, get granted options because they're tied to their performance in some way. But if then an employee said, oh, why did you get that option and I haven't got one? And the other employee said, because I brought in a huge amount of business last year, would you then say, well, so it's not made available by reason of his employment, but because you can find another employee who didn't get an option, and therefore it must have been because he did particularly well last year. But that would then take out of this scheme lots of employment-based
Yes,
securities option.
Yeah, indeed, and that's why I said that one might have to cast the net a bit more widely than causa, because it can't simply be about I've done the work, therefore I get paid, because the employment is a step back from that. So in the relationship scenario,
she does seem to be saying that because Mr. Carnegie was also employed and didn't get an option, that must indicate that the reason why Mr. Noble got the option was not his employment. But I'm just testing whether that can actually be right.
yes, but on the facts it goes a bit further than that. If I could take your ladyship to page 373. Just at the bottom of that page at Roman 7. This is within the document summary report of principal legal terms dated 9th March 2007. HMRC's case rests, in short, on the proposition that because Mr. Noble's appointment as a director was a precondition of the funding, then really everything else that went along with the funding must be by reason of that employment. What we're told here about Mr. Carnegie in particular, my lady, is that Marcus Noble is to be appointed to the board as executive chairman, and that's the precondition that my friend is talking about. But it goes on to say that we understand that also as a condition of the investment, Scott Carnegie was recently appointed to the board as finance director. So in terms of the relationship between the appointment on the one hand and the refinancing on the other, Mr. Noble and Mr. Carnegie were in the same position.
So are you saying that the only difference between Mr. Noble and Mr. Carnegie was that Mr. Noble had the 2006 option? Is that what you're saying, that the test is that you have to identify what's the sole difference between two people, one who has the option and one who doesn't?
I'm not quite saying that's the sole.
How that works.
I think she's just trying to apply Lord Denning's test in the previous paragraph, where something analogous to the two students example.
Yes. Here are two people in the same position. Appointment as a director, a precondition of this refinancing. One gets options, one doesn't. What's the difference between them? In a sense, it's perhaps a means of.
Yes, but what I'm saying is that the difference between them might not be their employment, but that doesn't necessarily mean that they don't get the opportunity by reason of their employment. Just as an employee who gets an option because they've done particularly well is still getting the option by reason of their employment, even if there are other people who are also equally employed in the same job who didn't do so well and so don't get the option.
Yes, Lady, I'm certainly not saying that this difference is conclusive. All I'm saying is that this difference in this case does support the proposition that Ms. Noble's, the bare appointment as a director was not granted the 07 options, so the right to opportunity was not available by reason of his appointment as a director. So Mr. Noble's and Mr. Carnegie's titles were different. So Mr. Noble was executive or non-executive chairman. Mr. Carnegie was to be the finance director. As we can see, they were both to devote 1 to 2 days per week. They were both to be engaged for at least 12 months. They were both to be paid £4,167 per month for their services.
Yes, I think you can say that it wasn't that the fact that they were both directors, or the fact that Mr. Noble was a director, wasn't the sole cause for the reason for the grant of the 2007 option. But as I understand, Wicks and Firth, neither Lord Denning nor Lord Oliver suggested that there had to be a sole cause.
No, indeed. But it still has to be, at least in some way, an operative cause, or, as I say, perhaps not quite as close as a causa causans, but certainly an important reason, crossing a particular threshold that does have a real link between or to the availability of the right to opportunity to acquire the securities options. So my submission, the fact that Mr. Carnegie, being a director in the same position in terms of levels in the hierarchy, hours to be worked, remuneration, did not get an option, at least supports the conclusion that the right to opportunity to acquire the replacement option was not by reason of Mr. Noble's employment. Now, I'll go to this just now. That's supported in my submission if one looks at the two documents by which the two transactions in question took place. So first, the replacement option, which is at page 413. Page 413. I think all I specifically want to take the court to is first clause 2 at page 416. Clause 2 at page 416. 2.1 is the grant of the replacement option. We have a reference to an outdated reference to Section 744 of the Companies Act, 1985. Then have in clause 2.2, no consideration shall be payable for the grant of the option. Now, if the avoidance of doubt, this agreement is governed by Scots law, so where consideration is used, it's not being used in the technical sense it has in English law. In my submission, all this means is that nothing is going to be paid for this option. However, what also is being required to be done is 2.3. So the existing option shall lapse with effect from the time of execution of this agreement. In my submission, it's therefore quite clear that the deal is Mr. Noble has to give up the original option. He doesn't have to pay any more than that, but he will get the reduced rights under the replacement option as and when he signs the document giving up the original option. Now, I accept that, as discussed, 4.3 and 4.4 mean a slight lengthening of the period during which the option can be exercised. In my submission, though, that, on the face of it, looks to be just arising out of the fact that there happened to be different dates of these documents. There's no suggestion that it was something specific or some specific issue that the parties actually directed their minds to at the time. As it turned out, 10 years later, an important difference, but at the time, which is what we've got to look at, at the time of the document in 2007, in my submission, there's no suggestion that anyone really thought about the extension to the option period. Clause 5.3 on page 418 says that it curiously says that the option is over shares that will that aren't F ordinary shares, but will rank pari passu with F shares of the company in issue. As a similar clause 6 about variation of share capital. And in my submission, importantly, clause 11 on page 420 contains an entire agreement clause. Now, that in my submission is important because there is nothing in this agreement that links the options to Mr. Noble's appointment as a director. Now, usually in the case of employee share options, there are provisions, for example, about good leavers and bad leavers, that sort of thing. Here, there is nothing of that sort. No requirement for Mr. Noble to be a director or continue to be a director. No indication that if he resigns as director, he will lose the options or anything like that. I mentioned clause 12, governed by Scots law, page 41, governed by Scots law, so the reference to consideration is just is not a technical use of that. If we turn, please, then to Mr. Noble's letter of appointment at page 387. Page 287, in particular at paragraph 5 at the foot of that page, in consideration for your services as a director of the company, you'll be entitled to receive £4,167 per month plus VAT if applicable, to be payable quarter in arrears. So the agreed fees for work done as director were £50,000 per year. The reference to VAT reflects clause 12 on page 388. It doesn't. The agreement is that Mr. Noble isn't an employee and shan't constitute a contract of employment. It anticipates that fees received are subject to taxation under Schedule D. An outdated reference to what is now the trading income charging provisions. Now, of course, that doesn't make any difference for our purposes because a director is deemed to be within the employment income provisions, as is common ground. However, it does show that at least the intention of the parties is one can't simply assume that if Mr. Noble had refused appointment as a director.
So you accept that that deeming provision applies, even though it's quite clear factually that he wasn't an employee?
Well, it's quite clear in my yes, he wasn't an employee, but he was a director.
Right.
Again, in a sense, it's perhaps not a deeming provision, but I think that Section 5 in ITPO 3 says that someone who's a director counts as an employee for the purposes of taxation under this Act.
Right. And that,
Which section is that, sorry?
I think it's Section 5, my lord.
Thank you very much.
So despite the party's intention that he shouldn't be an employee, nonetheless, he is deemed to be within the employment income provisions. In my submission, this clause, however, does show that HMRC can't simply assume, having not taken any evidence about it at the first-tier tribunal, that if he had said, no, I'm not going to be a director, I want to remain a consultant, he would not have got the 07 option. The final point on the engagement letter is, again, Clause 13, an entire agreement clause. An entire agreement clause. Setting out the entire agreement between Mr. Noble and Director relating to the subject matter of it. Again, here the point is the mirror image one, that this letter of appointment does not anywhere refer to the options. It doesn't identify them as having anything to do with his employment, further as remuneration for work he is going to do, further as having been granted because he agreed to be a director, or further as something that he would have to give up were he to cease to be a director at any point. So again, I'm not putting this forward as something conclusive, but in my submission, it certainly supports the proposition that the replacement options were not granted because of his agreement, or the right opportunity to get the replacement options was not available by reason of his agreement to become a director. So having looked at those documents, I now return to the first-tier tribunal decision, back at page 172.
Paragraph.
Sorry?
Paragraph.
Well, paragraph, we've just been looking at 105. I think I don't know anything more to say on that. My submission is that it does at least contain a finding in fact. It may be more than that, but in my submission, as a finding in fact, it identifies that really, in the absence of the original options, there would have been no replacement options. By implication, it implies that appointment as director was not relevant. To the availability of the replacement options. On paragraph 106, the FTT says respondents wouldn't dispute that these are the facts in relation to the replacement option. That, in my submission, underlines that at least what the first-tier tribunal thinks it's doing is making a finding of fact. Of course, now HMRC say they do dispute these facts, and my friend says in his written case and in oral submissions today that had the first-tier tribunal asked HMRC, HMRC would have said that. Of course, that's not the way litigation works. If you want to dispute something in litigation, you put your evidence, you bring your evidence to the tribunal and you make your submissions about it. So in my submission, it's unfair for HMRC to criticise the tribunal for saying that HMRC wouldn't dispute that these are the facts, where HMRC didn't dispute that those are the facts at the tribunal. Turning next to page 173, the FTT at paragraphs 102 to 113. Sorry, 112 to 113.
This is moving into subsection 3.
Yes, in subsection 3. Yes, for the avoidance of doubt, in my submission, what the FTT finds in paragraph 105 is enough for a respondent to succeed on subsection 1. The tribunal then goes on to consider subsection 3. And if I can invite the court to read those two paragraphs, 112 and 113. In my submission, here on the face of it, the tribunal seems to be saying that the right to opportunity to acquire the replacement option was made available by Vermilion. But if one actually reads closely what the tribunal is saying, it is basing that conclusion solely on the fact that Vermilion was the grantor of the option, of the replacement option. Now, so far as what the tribunal does here is make a finding in fact, in my submission, it presupposes an error of law by the tribunal, because the tribunal seems to be asking itself a question simply, who granted the option? In any event, my lords and lady, I would submit that what the tribunal really found, in fact, is in paragraph 141, which we've looked at already, on page 180. Page 180. So after having discussed the issue of how to approach and apply deeming provisions, having concluded that on the basis, if the fact that the option was granted by Vermilion meant that the right to opportunity was made available by Vermilion, having concluded that would be an absurd position, the tribunal, for various reasons that I'm not going to go into.
I mean, we're looking at paragraph 141.
Yeah, so 141.
And you're saying that's a finding of fact? How?
In my submission, what the tribunal says, analysis of the underlying causes that led to the grant of the 07 option and the economic mechanism whereby the 07 option came to be granted, when viewed realistically, meant that Mr. Noble's right to acquire the 07 option was not made available by Vermilion as his employer. Now,
this is looking at underlying causes and looking at your argument, which was, I think, recorded back in 111, that the 2007 option was made available by the surrender of the 2006 option. But the difficulty with that, I would suggest, that is if you look at 4713, it's talking about looking to see whether something's been made available by a person, not the reason why it was made available. So where does the learned tribunal judge find a statutory basis for limiting the option, limiting the deeming provision by reference to the reason why it was made available?
Because in my submission, the issue of who made the right to opportunity available is a question of fact, and one has to answer it by reference to all the facts and circumstances. And they include, for example, the mechanism, how it came about.
But who has the tribunal judge identified as the person who made the option available, if not Vermilion?
Well, my first submission is that it's not necessary to identify someone who is not the employer. My second point is, in 111, the argument is that it wasn't made available by Vermilion. It was made available either by Mr. Noble surrendering his option or by the consortium investors.
That's
the point I'm making.
Yes, that's eliding who makes it available with why it's made available.
Precisely.
And that the why question is the 4711 question, and the who question is the 4713 question. But they're different questions, as my Lord Hodge says. So I can't see that whether somebody made available the right or opportunity or didn't can be affected by the reasons why it was made available or not.
Well,
Isn't
yes,
the point of subsection 3 to ask a different question from the question asked in subsection 1?
yeah. So maybe that the tribunal was wrong to look at the underlying causes of the grant of the replacement option, but in my submission, it's not quite as simple as saying one can't take the reasons why it was granted into account. One's not focusing on the reason, but one's looking at all the facts and circumstances to identify who made this option available, who made the right to opportunity to acquire it available, who said to Mr. Noble, Mr. Noble, you are free to reduce your options over shares in this company, where here's an opportunity to do that. I mean, as I mentioned at the start, it's slightly odd way to put it.
They could say that till the cows come home, unless somebody actually grants him the option. He doesn't have that right.
Yes, well, as mentioned, well, unless someone grants him the option, the right to opportunity, he may not have it.
Yeah, the consortium didn't grant him the right.
Well, let me just. They didn't grant him the option, but what we're looking at is a right to opportunity to acquire it. So we're looking at something.
They don't have power over who grants options in Vermilion shares, do they?
Well, on the facts of this case, Milady, in my submission, they did, because they could say to Vermilion, we will invest money in you, but only if, number one, you reduce Dixon Minto's options. Number two, you reduce Marcus Noble's options. Number three, you fire David Osborne. Number four, you appoint Marcus Noble. Number five, we want it in the form of loan notes initially and equity later on. Number six, you've got to hit equity milestones, which are all set out about sales to particular companies, various offices around the world of client software. So my submission, Lady, it is in fact the case that, as strange as it might be, that Mr. Noble was given a right or opportunity to reduce his rights to acquire shares. If one looks at page 379, sorry, page 370, page 370, This is the start of the summary report of the principal legal terms, which was dated, I think, 9th March 2007, prepared, as we can see, on page 369 by Dixon Minto. And my learned friend took us through the first tier tribunal's findings and fact. I think it was at paragraphs 33 to 36, to show that Mr. Noble had input into structuring this deal, as my learned friend put it. Now, if I ask, at paragraph 1, we act for Vermilion Holdings, summary report prepared by us, and so on. At the end of the fourth line, this summary report has been prepared for the company, that's to say for Vermilion, in order to summarize the principal legal terms of a rescue funding package which it is proposed to be made available to the company. So this rescue funding package, into which, as my learned friend said, Mr. Noble had input, is being made available to Vermilion. The package included the appointment of Mr. Noble agreeing to become non-executive chairman, because he wasn't in that position at the date of this document. It included a reduction in Dixon Minto's options. It included a reduction in Mr. Noble's options.
Let's go back to the wording of 4713. A right or opportunity to acquire a securities option made available by a person's employer, etc., etc. Now, the only person who could give a right to acquire the securities option would be the person who could grant the securities option, would it not?
Well, not in the case of assignation, for example, my lord, or in the case of, for example, the employee trust that my Lady Rose referred to earlier.
Yes, well, okay. So, or a person connected with a person's employer, it says.
Yes, and I'm not sure if off the top of my head if an employee trust would meet.
So it's talking about a right or an opportunity, which presumably means an offer open to acceptance.
Well, I'm not sure it necessarily goes.
You think it goes further than that?
It says, if again, my lord, if what it meant was an offer capable of acceptance, that's what it would have said.
Okay.
And it would also, or it could simply have achieved the same, or possibly the same. Well, no, it wouldn't have achieved the same aim by making it simply the grantor. The grantor being the person's employer. Sorry. So my submission, my lord, the language of this provision is simply cast in a different way from a rule that would simply look at either the grantor of the option or someone who had offered, made an offer for someone to purchase or otherwise acquire a securities option. And that is, in my submission, for example, one can see that in the case of Price. Our friend took us through Price and showed us the attention that the tribunal paid to whose opportunity, or what opportunity was it. On the one hand, for Mr. Jenner, the director, to acquire the option, and on the other hand, Mr. Myers, the taxpayer, entering a tax avoidance arrangement to acquire it. It was only the former's opportunity that was granted or made available by reason of employment or by his employer. Mr. Meyer's opportunity was a different opportunity, and it wasn't made available by his employer, but by someone else's. In my submission, was made on the facts of this case. Who made the right? Who created the chance? Put it that way. For Mr. Noble to reduce his rights. In my submission, the answer is the consortium investors.
The answer is?
The consortium investors. Or in the alternative, Mr. Noble, because he only had the opportunity to acquire the option because he had the original option. I would mention in this document too. Well, I think I've taken the court already to paragraph 7 on page 373, which concerns the appointment of Mr. Noble and Mr. Carnegie. That paragraph not referring to options. To complete the picture in this document, page 374. Page 374 at Roman 9. Existing share option arrangements are to be amended, oblique cancelled as set out in section 5. Section 5 is on page 376. Page 376. At present, the company is party to option agreements with 3 option holders, which, conditional upon the company achieving the first equity milestone, is proposed to be treated as follows. So far as there's any express condition on that, it relates to, in fact, the sales of product to a customer's office in, I think, Milan. One can see that at page 372. In any event, with Roman 1 refers to the options to each of 22 nominees limited and Quest Advantage Limited, the latter being Mr. Noble's options. It's proposed, about 5 lines down, it's proposed that these option agreements are to be amended with the effect that each of these option holders' entitlements will be diluted in line with the dilution of those option holders' equity holdings in the company following completion by the consortium of the investment. So, for the ones without, both 22 nominees and Quest Advantage were also shareholders in the company at the time. Those shareholders would be diluted by the consortium's investment, and a corresponding dilution was to be made to their options. One can see that they were shareholders by the schedule to this document on page 379, which identifies them as holding B shares and C shares, and gives the details of their shareholdings at that time. So far as cancellation is concerned, cancellation is in relation to the other individual who had enterprise management incentive options which is referred to in Little Roman 2, just under there.
Which page?
Again, sorry, page 376. Page 376, section 5, Little Roman 2.
Thank you.
And that's where it is envisaged that options will be cancelled.
Yes.
All that was envisaged at the date of this, when it was clear that Mr. Noble's, one of the terms being offered to Vermilion was the appointment of Mr. Noble. It is clear that what was envisaged there was amendment of existing options rather than cancellation and re-grant.
But that ultimately wasn't the deal put in place.
No, again, that's right, it wasn't the deal put in place, but my submission is that that intention at least supports the idea, supports the conclusion that the replacement options, the right or opportunity to acquire them, was not granted by reason of Mr. Noble's employment. All it was a decision as to a legal mechanism to achieve a result which
So I thought we moved from subsection 1 to subsection 3.
Yes, sorry, Lord. So
We seem to be flitting between the
Yes.
two. And it would help me, certainly, I don't know about my colleagues, if you were to let the court know
yes, I
what
apologise.
your position is as to the first-tier tribunal's treatment of the limitation of deeming provisions, if that's part of your submission.
No, my lord, I'm not supporting.
You're not proposing to address that?
No.
Okay.
Nope. It's not in the way the first-tier tribunal did. That's my submission. That's not correct. And overall, of course, my submission is on subsection 3 that this document makes it clear that any right or opportunity being given to Mr. Noble is being made available by the consortium investors and not by the company.
So, sorry, I didn't quite understand what you just said in answer to my Lord Hodge. Are you not now maintaining that if this does fall within the wording of 4713, nonetheless, because it's anomalous and unjust, etc., the deeming provision shouldn't apply?
Well, lady, I think I say something about that in my written case. I don't propose to.
Okay.
You're not supposed to go beyond your written case.
No, I don't propose to defend.
That's entirely fine. Thank you.
I apologise for not making that clear.
Was it put that way by you in the first-tier tribunal that it was the consortium of investors who made the option available? So I can't see any reference to that in the summary of the argument. I'm not saying it wasn't, but I'm just inquiring.
Well, I think at 111.
Yes, 111.
The second page of 111.
Oh, yes.
It was either the surrender or the shareholders of Vermilion.
Right.
And not the company itself. That was your position.
Yes, that's right. That's exactly right, my lord. I could.
Thank you.
So.
Oh, I see. The reference to the shareholders of Vermilion there is not just the body of shareholders, but the
That's right.
consortium.
It's the consortium I think you were talking about. Have I read that correctly?
Yes, that's right, my lord. That's right.
And when the tribunal makes its finding on this in 141,
Yes.
I take your point that they don't actually have to identify a positive, that they just saying it's not, who's not made it available, but are they saying that the right was not made available by Vermilion, or are they simply saying something rather different, which it wasn't made available by Vermilion as his employer? Are they drawing a distinction between capacities?
In my submission, no, my lord. All that the two bits, the words "made available" and "employer," are simply being quoted from the text of legislation, and there is no certainly there was no argument about different capacities before the first-tier tribunal, and it may be that it would have been better phrased by Vermilion being his employer.
Right.
But in my submission, that's the sense in which the tribunal was using that phrase there.
So are you submitting that applying Edwards and Bairstow principles, we shouldn't interfere with that unless that's a conclusion no reasonable tribunal could have made, or that it's based on some error of law?
Yes, my Lord. Yep, in my submission, that's a finding in fact that can't be disturbed except upon Edwards and Bairstow principles.
Yes, but yes, I see. I mean, the principal decision occurred up to paragraph 140, and you're finding only on the alternative approach in 141. Is that right?
Yes, my Lord. My submission is that the principal decision is basically the tribunal's legal analysis of how deeming provisions work, and I'm not supporting that analysis, but it doesn't depend. But as far as it's based on a finding in fact in paragraphs 113 and 114, that finding in fact is infected by the error that the tribunal believes it to be sufficient in law for a right or opportunity to be made available by someone if that person is the grantor of the option. In my submission, the finding at paragraph 141 is also more consistent with the proper approach to statutory interpretation set out in UBS, for example, because the tribunal expressly states that in 141 that it's looking at the matters realistically.
But the tribunal judge doesn't really make clear whether she's accepting your argument that subsection 3 covers what had made available the right as well as who. We simply don't know from that paragraph whether the tribunal judge is accepting the submission that she recorded in page 111, that it was the surrender of the option that caused it.
Yes, well, in page 100, paragraph 111, sorry, the two alternatives were put forward, either made available by the surrender of the original option or made available by the consortium investors. The tribunal doesn't identify in paragraph 141 which of those, if either.
Well, it must be. She said she's adopting your submissions.
Yes, so I suppose, yes, there must be one of them. There must be one of them.
So it's either the consortium or Mr. Noble?
Yes, or Mr. Noble surrendering the existing ones, or the consortium saying to the company.
But she doesn't seem to be confining it to Mr. Noble. She says who or what. So she's interpreting 7413 to be speaking of not just by an individual, but by reason of something.
Yes, let me just...
And it's a very terse alternative finding.
Yes. Well, of course, I mean, there are circumstances in which I would submit quite clearly a right to opportunity is not made available by a person. So, for example, if an employee having been granted options dies without leaving a will, those options will pass to someone else by laws of intestacy. It can't be said that the right to opportunity of the legatee to acquire or the beneficiary to acquire the options has been made available by someone. It's been made available by the death of the existing holder. So my submission.
Well, no, it's made that's the price situation, isn't it? That the options come into the hands of somebody else, but they're still being made available to that person by the same person who made them available to the deceased. The reason why they're now not available to the deceased but are available to the legatee or whatever is because the deceased died. But it's not. You're mixing up cause with identity. Isn't that exactly? Then you could have said, well, it was Mr. Jenner who made available the option to Mr. Myers, but that wasn't what the court decided.
No, the court decided that at least it wasn't the employer company who had made the right option available, the right opportunity available to Mr. Myers, and that was the point. That was how the tax avoidance arrangement fell down.
No, well, I thought that they decided that it was, but it was not by reason of Mr. Jenner's employment, and Mr. Myers wasn't employed by them.
Well, maybe I'll check that way. That might be my misunderstanding of it. But in any event, here, the language of the section focuses on the right or opportunity to acquire a securities option. So if one looks at a beneficiary in intestacy, for example, that acquisition of a securities option, the right or opportunity to make that acquisition isn't made available by the grantor of the option, in my submission. It becomes available because the existing holder of the option dies without leaving a will. So, my submission is that it may be unusual for a what to be making available the right or opportunity. In that example, the death of the existing holder. But that's not a reason in my submission to the reference to or what in parentheses in paragraph 141 in my submission isn't a reason to suppose that the tribunal had made an error of law in the interpretation of that provision. In any event, in that paragraph, the tribunal answered the question it had to answer on the facts. Was the right or opportunity made available by Vermilion? The tribunal said no. That's enough to mean that subsection 3 doesn't apply. The tribunal doesn't have to go on and find and make a finding as to who did make the right or opportunity available. And maybe the tribunal couldn't decide between, on the one hand, the consortium investors, on the other hand, the fact that Mr. Noble was willing to give up his original options. But either way, in my submission, the tribunal's finding is quite clear that looking at the facts realistically, which is what the tribunal is required to do, the right or opportunity to acquire the replacement option was not made available by Vermilion, by Mr. Noble's employer. That's, I think, all I want to say about the decision of the first-tier tribunal, unless there is any further questions from the bench about that.
Thank you.
I want to make some reply to a couple of other points of fact that HMRC has put forward. My other friend, in both his written case, paragraph 25, and in submissions this morning, said that the replacement option was not on any view payment for the original services.
Sorry, I didn't hear that.
Sorry.
He said at paragraph 25.
Paragraph 25 in his written submissions, written case, that the replacement option was not on any view payment for the original services leading up to the finance exercise in 2006.
Thank you.
And if looked at in isolation, that's obviously correct. But the context again says that. If it's accepted as it is, that the original option was payment for those services, in my submission, it's replacement which essentially reduced the rights involved in that payment.
Yes, I mean, your position is that the 2007 option was a diluted replacement as payment for the pre-2007 services.
Indeed,
Yes.
indeed. And this is made clear in my submission if one thinks through another point made in paragraph 25 of my friend's written case, which is that if Mr. Noble had been paid money instead of receiving the replacement option, that would clearly have been employment income. Now, in my submission, that's simply wrong, because if Mr. Noble, instead of the replacement option, had received money in a contract by which he gave up his original option, the money would not have been employment income, it would have simply been payment for the surrender of the 06 option. It would have been charged capital gains tax. It would have been charged capital gains tax in the normal way. I don't need the authority of Abbott against Philbin for that, but because the disposal of an option is simply disposal of a capital asset for capital gains tax purposes. As one can see, for example, in the other case of Wilcock and Eve, which is in the bundle. The other point to reply to in particular is in HMRC's written case at paragraph 25.5.
75.5.
25.5.
25.5, sorry.
It's on page 54.
Yes.
On page 54. About a dozen lines down, there's a line beginning Director of VHL. Director of VHL. Then makes the point, as my Lord Hodge has mentioned, that Dixaminto acquired a similar option is irrelevant. It then says there is no evidence on the basis, if that should be of the basis upon which Dixaminto was granted a new option in 2007, or on the basis upon which that could cast any light on Mr. Noble's new 2007 option. In my submission, that's not correct, because it's quite clear these two options from all the documentary evidence were simply treated in the same way.
Yes. It's an ambitious submission.
My Lord has my point. So Humphrey might describe it as courageous, but maybe it's not goes quite that far. Anyway, in my submission, there is adequate evidence of the basis on which Dixon Minto, via its nominee, received its replacement option, and there is more than adequate evidence that it was the same thought process, same considerations, same people who made that available as made available Mr. Noble's replacement option.
Well, today, I think HMRC's position, having withdrawn, I think any concession in relation to the banker's example of a bank handing out share options to all its customers, which might be an example of rather ambitious problem finding that particular example, because I don't think a bank would be likely to do that very often. But be that as it may, I mean, the Revenue's position is that it might be the case that Dixon Minto also would fall within subsection 1.
Yes, my Lord.
Which means it's been given quite a broad ambit as employment-related money.
Indeed, my Lord. In my submission, HMRC's submission does indeed lead there, and that demonstrates that the submission cannot be right. If that submission is right, then Dixon Minto, an unconnected party who is agreeing to have its options diluted for reasons not connected to any employment of it or its individuals, that the partners in Dixon Minto are having to pay income tax and national insurance contributions as if any gain made on its options were employment income.
And this may be me problem finding, but if the consortium, as well as putting money in, had asked for some options so that they got a bigger stake if things went well, presumably the same would apply there.
Yes. Yes, my Lord.
As long as Mr. Noble is the linchpin, he is the other person in subsection 1, and the same would apply.
Yes, my Lord. And this leads, in a sense, to.
But this is the other side of the coin that the first tier tribunal said. Well, look at Mr. Carnegie. He's also employed, and he didn't get the option, so that must mean that the option is not granted by reason of employment. But here's Dixon Minto, who are not employed, who did get the option, and so that also must mean that the reason for the option is not employment. But the question is whether those are true sequitors or non sequitors, both Mr. Carnegie and also Dixon Minto.
Yes,
that the fact that you can point to somebody else who also gets an option who is not employed, does that automatically mean that the reason why you've got the option can't be your employment? That's what the point that the judge was making out of this, wasn't it?
Yes, please. And for one doubt, I don't say that it necessarily follows as a matter of deductive logic that because Dixon Minto, not an employee, got options, therefore Mr. Noble's options aren't because he's an employee, nor that because Mr. Carnegie, an employee, didn't get options, again, therefore Mr. Noble's an employee did get options. The options are not because of his employment. I don't put it as a matter of deductive logic, but I do say that it's relevant in assessing, as a matter of all the facts and circumstances, for subsection 1, what was the reason for Mr. Noble getting these options?
You could also make one view that even if one of those by itself may not take you all that far, if you've got both sides of the coin, so to speak,
Indeed.
both ways round,
Indeed.
that does amount to quite a strong inference.
Indeed, my lord. So in my submission, those two facts are quite strongly supportive of the conclusion that for subsection 1, the by reason of test isn't met. And this brings us to the point that, of course, as the Inner House said, HMRC's case is that because Mr. Noble's appointment was a condition of the financing exercise, therefore, the right opportunity to acquire, Mr. Noble's right opportunity to acquire replacement options must have been by reason of his appointment as director. Now, in my submission, there are a variety of things wrong with that. The first, it doesn't really get to grips with the fact that it means everything else that happened in the refinancing exercise.
You're saying the Inner House said that? Did you?
The Inner House. Sorry, the Inner House. That's HMRC submission. Sorry.
Oh, HMRC submission.
The Inner House said that wasn't right.
Yeah.
That was Lord Malcolm and Lord Docherty. If it is right, and I think the point made in my submission before the upper tribunal as well, was that it didn't explain then why it wasn't the other way around. Why is the grant of the replacement options not by reason? Why is the appointment not by reason of the willingness to take on replacement options? It doesn't get to grips with the consequence that everything then that was required by the consortium investors would have been required by reason of Mr. Noble's appointment as director. And fundamentally, the problem with the proposition is that it was the agreement to finance was what was by reason of, or was by reason of the employment and the satisfaction of other conditions. That was what was the end result brought about by all these other facts taking place and being agreed to. But it can't be said that each of the conditions that the consortium investors laid down was a cause of the other, or was by reason of the other, which is where, in my submission, the Inner House was correct in describing it simply, I can't remember the exact words used.
If each was a cause, each of the conditions laid down by the investors was a cause of the other, would that not bring you within the scope of subsection 1 as interpreted in Wicks?
Well, my submission is that it's simply not possible for them all to be the causes of each other. It doesn't work as a sentence.
I thought you were just saying to me that each was.
No more. Sorry, I'm saying that's where HMRC submission leads.
Because in the upper tribunal, their position was that employment was a condition of the benefit being granted. Now, if employment was a cause of the benefit being granted, and the benefit being granted was a cause of the employment, is the test not met?
in my submission, the upper tribunal was wrong. If we're looking at the paragraph 81, which is on page 147, I think. So the employment of Mr. Noble and the grant of the 2007 option, this in the decision of the upper tribunal, are two of the conditions of the rescue package. The replacement option was conditional on the other conditions being satisfied before it could go ahead. Now, nowhere in any of the documents does it say that. They're simply treated in all the documents we've looked at as separate conditions which have to be met separately before the consortium investors will put in the money they're willing to put in.
The simple point is the fact that two things are conditions of something else doesn't mean that each of those two things is a condition of the other.
Precisely. That's all there is to it. And that's in my submission where the upper tribunal went wrong and where the majority of the inner house were correct. Right. I think that's all I want to say about the facts. I can turn now to the case law, and as my friend did, I can deal with that reasonably briefly. I'm not sure, unless the bench has any further questions about the facts at this stage. The case law I can deal with reasonably briefly because I'm not sure there's a great deal of difference between the parties about the tests that are laid down. Wicks and Firth, of course, the two tests by Lord Denning on the one hand, Master of the Rolls, and Lord Justice Oliver on the other. Lord Denning is at page 988 with bundle, with his question at the end, why do you get the scholarship and not me? Because my father is employed by ICI. In the present case, of course, that's about the by reason of employment test. My submission is that the answer is either why does Mr. Noble get the replacement option and not, for example, Mr. Carnegie? And that's because Mr. Noble had the original option, or possibly because it happened to be the case that the legal mechanism chosen for the amendments, the intended amendments to the original option, was as for unconnected reasons, cancellation and re-grant.
Well, suppose in a different situation there were two students, both of whose parents worked for ICI, but the money available from ICI was only available if you went to a particular, one of 10 particular universities. So one of them got the scholarship because he went to that particular university, and the other one didn't get the scholarship because their university wasn't on the list. And one of them had said to the other, why did you get a scholarship and not me? And the answer would have been, because I'm at a university which is on ICI's list. Would that mean that the scholarship to the one who was at the university was not by reason of his parents' employment by ICI.
Normally, I accept that in that case, it would still be by reason of employment.
Well, why? I mean, the answer to the question's got nothing to do with the employment of the...
Well, because, Milady, in the case, in fact, there were other conditions, of course, to be met. One of which was, for example, an assessment of how much grant was being provided and how much one's parents were able to provide, and ICI broadly made up the shortfall. So the answer to, well, why do you get this much, as opposed to me, I think the gentleman in question got rather more than the lady, just because there are reasons. So yes, there are other conditions to be satisfied. But that doesn't mean that in that example, one still couldn't say well, first I get the employment because my father's employed by ICI, and also because I meet the other conditions. So yes, Lord Denning's test is not quite enough, and as I've mentioned, my submission is that the causa sine qua non is not enough for the by reason of test to be satisfied. The way the question is put by the Master of the Rolls here also doesn't necessarily recognise the fact that there may be more than one cause, more than one reason, although the Master of the Rolls has made that quite clear before that in the same paragraph.
Well, I think he's trying to identify a situation in which everything else is equal except for the employment, and then saying, can that make the difference? And he's saying it can, and that's his test. He's not trying to provide a universal test, as it were, which will eliminate other possible conditions. Yeah.
So in the answer of people going to two different universities, the answer might be, well, in this case, you don't get it because you go to the university that doesn't count. But if you had gone to that right university, because of your father's employment, you would have got a scholarship. So one can see that there are two causes, or two by reasons of, and there's the way it's worded, the particular point that Master Rolls is trying to demonstrate doesn't quite fit with that. But in my submission, it doesn't. It doesn't mean there can't be two causes. As I mentioned also, my submission is that a causa causans might not be the right test. It might be something a bit more, a bit broader than that. To cater to the fact that one may well have to go slightly further back in the chain of causation to find employment in circumstances where it's nonetheless appropriate to regard the by reason of test as having been met. So as far as Lord Justice Oliver's test is concerned, I think it's at the bottom of page 993 to the top of page 992. I think it's common ground between my learned friend and me that this is the test that's been generally preferred by a variety of courts since this decision, and all the references are in, I think, both written cases. Lord Justice Oliver rejects or finds the philosophical distinction between a causa causans and a causa sine qua non as unhelpful. No intention to remunerate the employee is necessary, and of course I accept that. And reflecting that, of course, that's why I say that the absence, for example, of any reference to the replacement option in Mr. Noble's appointment letter, again, isn't conclusive, but in my submission is nonetheless a factor that points towards a lack of connection. Lord Justice Oliver's gloss is the question, what is it that enables the person concerned to enjoy the benefit without the necessity for too sophisticated analysis of the operative reasons why that person may have been prompted to apply for the benefit or to avail himself of it. In that, one has to remember, of course, that in that case, the legislative test was whether a benefit was provided by reason of employment. So one has to read this passage accordingly. So in the present case, it would be, what is it that enables the person concerned to enjoy the right or opportunity to acquire the securities option? In my submission, of course, on the facts of this case, it is either the holding of the original option or if one wishes, the almost administrative decision as to the legal mechanism in fact chosen.
Is it one of those situations where the courts are likely to take the view that it might be dangerous to start putting glosses on the statutory words?
Yes, Lord. I did have in my mind to say that, of course, as has been said in a number of cases about the by reason of test and others in this context, one must always return to the words of the statute. Glosses are helpful as guidance or pointers, but they always depend on how the judge in particular has approached the case. So while, yes, for example, Lord Denning's gloss, why do you get it, not me, is helpful, but doesn't give the answer, because in the case of two different universities, it doesn't give the right answer. One has to return to the words of the statute, and inevitably, or I dare say it may be the case, that this court gives its own gloss or explanation of how this phrase, or how these phrases, how these subsections work on the particular facts of this case. But one has to always return to the words of the section. Section 471 was the right opportunity to acquire the securities option available by reason of Mr. Noble's employment. Section 4713 was the right or opportunity to acquire the replacement option made available by Vermilion Holdings Limited. In my submission, the answer to both of those questions is no. The reasons I've already given. If I might have a similar minute to that requested by my learned friend at the end of his submissions, just to get my own thumbs up, hopefully. The only final point is to mention that the purpose of these provisions is ultimately to tax as income the rewards of employment. Now, that purpose doesn't necessarily give a clear solution in terms of the wording of this legislation. But the justice of this case, in my submission, is quite clear. Mr. Noble's rights were reduced. The value of those rights were reduced at the time. That can't count as a benefit at that time to him. And it would be, in my submission, a curious result if that economic substance of what happened in July 2007 was treated as Mr. Noble getting something, when in my submission, rather he gave something up. Unless there can be further assistance, I will conclude my submissions again by inviting the court to refuse the appeal.
Mr. Simpson, thank you very much.
Obliged, my lord.
Mr. Ghosh.
I'm grateful and may it please the court. Please, may I have the court's indulgence in one very small point? I'm going to take the court to the summary of legal terms. You've seen it before, but this is in response to something Mr. Simpson said in the course of his submissions, which is these conditions are all the same. The precondition of directorship, the precondition of the reduction of the options. That is not true. That's not right. Please may the court look at MS 376. It's a summary of legal terms telling what the rescue package is. Clause 5 is the treatment of the existing options. So these are the two 2006 options. And it's critical that what was proposed in this rescue package was you've got these options agreements and conditional upon the company achieving the first equity milestones, these things are going to happen. And the equity milestones you'll see at 371 and 372. By 15th May 2007, the company has had to enter into a signed contract.
371, did you say?
371, my lord, and 372. That tells you what the first equity milestone is. Do you see that?
The equity milestone should be signed. Maybe summarise. So it's condition 3.4 and the table beneath it.
Exactly right. And the point I'm making is that the precondition that I have taken the court to of Mr. Noble being a director, that's not contingent on anything. He just has to be a director. And he was already a director by the time the first equity milestone would have been reached, and the company would have been benefiting from his expertise. Co-director, not consultant anymore, co-director. So it is simply wrong. And the factual analysis would have been misled in a very serious way. Nobody's fault. I'm not criticizing anybody. To say that the two conditions were the same. They're not.
So I haven't quite followed your point. You're saying that
the grant of the 2007 option, the amendment that was going to be, but
yes.
the new option that was contingent on the company reaching the first equity milestone.
Mm-hmm. And what who is pioneer in the role?
It's a client.
So this is an equity milestone applying to the new agreement.
And to the cessation of the old one, I think.
Exactly right. So we're
which is there described actually as an amendment, but that obviously changed.
Yeah. So we're in a world where this new option, the 2007 option, or the old amendment, I don't care which, would happen if and only if this equity milestone is reached. But on any view, the rescue package wanted Mr. Noble to be a director, no matter what. That's not contingent.
I'm sorry, I didn't hear that. On any view?
On any view, Mr. Noble, his directorship, his precondition of him being a director, that had to be satisfied on any view. That was not a contingent precondition.
Okay, they're not identical, but it doesn't make one a condition of the other.
They're both, well, I say it does. I don't want to rehearse my the 10 minutes I've got to go over all that again, but I do want to say that...
But the grant of the 2007 option, was that only made once this first equity milestone had been granted?
Yes. That's what this says.
Conditional on the company achieving the first equity.
Exactly right. So I'm simply making the point that there's a precondition of directorship.
Okay.
And if that didn't happen, nothing would happen. But it's only if the company did well enough post Mr. Noble's directorship and they'd reached this first equity milestone, then you've got this amendment of the 2006 option, which turns out to be the grant of the 2007 option.
So you're saying that I still don't understand this, the lapsing of the 2006 option would have happened anyway?
No, I think that's conditional too.
No, it's not. I'm saying neither would happen. Neither the lapsing of the 2006 option nor the grant of the 2007 option would happen unless this first equity milestone was reached. And I'm making the point that the precondition of directorship, that had to happen anyway, on any view.
But it makes the directorship a bit more distant from the option, because it shows you he could have been a director and yet never have been any alteration in the option.
No, I'd say it's the opposite. It shows that the efforts of Mr. Noble as a director in giving value to the company makes it more likely that he'll get this new option.
But there could have been a situation in which he became a director, but they didn't make the first equity milestone, in which case he never would have, there never would have been an amendment to his option.
Like any bonus or anything. Yeah. And bearing in mind the reason he took this deal was because his 2006 option would otherwise have become worthless. You could take it's speculation as to how what it tells us about the strength of the connection. So I don't accept my Lord Legate's observation. It makes it more distant. Not at all. It's the opposite. I work hard as a director. Company gets more valuable, hits the milestone. I get an option that's better than my worthless one. Next, yes, it's right. 420 sub 8. That reference to none of these provisions apply if it's to do with tax avoidance. That cuts across the approach of the first-year tribunal in paragraph 143. That construction is all different. Next, Mr. Simpson puts all the pressure on 4711 on paragraph 105. He took you to the contract of employment. He took you to clause 6 of the 2006 articles, not mentioned there. Mentioned Mr. Carnegie, not relevant for the reasons my Lady Rose gave. And no mention of the precondition of directorship, the non-contingent condition. No mention at all. And there's no implication from that the judge must have thought about it and then rejected it. It's not mentioned. Tribunals ignored it. Can't guess. And then on the facts, the precondition has been airbrushed out of the factual chronology in my learned friend's submissions, as has the extended term. He said it came to be important. The 2007 option had a real commercial consequence, that it was exercised at a profit at a time when the 2006 option could not have been exercised. It would have expired. That's a real commercial thing. So to describe this case as one where the only thing that happened to Mr. Noble was a reduction in his rights, on any view, that's wrong. On any view. Purpose, justice, all that. You've seen, and that's why I've taken you to the summary of legal terms and conditions. He was a director in March 2006. He was helping to turn the company around.
March
2007, I beg your pardon. Yes. He was helping to turn the company around, make it more valuable, try and hit these equity milestones.
The first equity milestone was only 2 months afterwards.
Yeah.
Yes.
But that was getting money in from the debt finance and the equity finance. Absolutely right. So value was being conferred by his work as a director. So I reject, respectfully, my Lord Legate's point about this somehow dilutes the connection. I don't think that's right at all. So we're in a world in which there is a condition, he needs to be a director, that wasn't accounted for at all by the first tier tribunal for 4711 purposes. Is it an operative reason? It must be. It's a precondition. That's what a precondition is. Without this condition being met, other things won't happen. That's all I want to say on 4711, 4713. I kept waiting. My learned friend at no stage made a submission that met my point, and that in fact met points put both to me and to him by the court, that 4713 deals with the identity of the provider of an opportunity and not the underlying causes. There's not a single submission he made that met that point. At 112 and 113 of the FTT decision, there's a finding of fact which my learned friend doesn't like. He doesn't like that one. He likes 105, but not 112 and 113. But it was found in terms that the provider of the opportunity was Vermilion. And 141, sorry, I have to find it.
You say that. Answer the simple question in the affirmative. Yes, she says that the right to acquire the 2007 often was made available by Vermilion, and explains that by the fact that that Vermilion eventually granted the option. But Mr. Simpson attacks that as an error of law because he says it's not about who grants the option, it's who provided the opportunity.
Yes, and to that I say the grantor of an option, the class of persons who makes the opportunity available necessarily always includes the grantor. 4713 extends to where the employer said intelligibly to provide an opportunity even if the employer or a connected person is not the grantor. But on any view, the grantor must. It's axiomatic. You can elevate this to a principle. And 141, if you please, if the court reads it at page 180, because my learned friend's abandoned all the pages and pages about deeming provisions, so this is all he's got on 4713.
I don't think he did abandon that. That's what I asked him, but he said he was just relying on what he said in his written submissions and not...
But he went on to say he was not defending the first tier tribunal.
He did say that. I wrote it down. He said he's not supporting it. It's the wrong way. That was his phrase. It's the wrong way to approach deeming provisions.
Yes, which calls into question Lord Malcolm's approach, which endorses that way.
Yes, and just...
But your time is running out.
It is, and can I just please take you to 141. If you look at the last sentence of 141, it could hardly be clearer, the approach of the judge, and it's wrong. The underlying causes is what she relies on to answer the 4713 question. And it's the very last words. They weren't granted on her analysis, which is the only thing he's relying on now, because they weren't granted, made available by Vermilion as his employer. What does those last words mean?
Well, I mean, the whole purpose of the deeming provision is to avoid that question.
Absolutely right, my lord. And I say 141, it's all over the place. It's a wobbly basis. And all I say about paragraph 49 of the division's majority judgment, that is Lord Malcolm, that is what is called into question if the approach to deeming provisions is not pursued. That's one. Two, my Lord Malcolm's approach of saying, well, I know that these are all conditions, he could hardly be clearer. He accepts that nothing would have happened without the directorship, but he says, oh, well, because you could express it two ways, the directorship's a condition of the new option, but the new option could be a condition of the directorship, that means I lose. And that, in my respectful submission, is an error. Proper question, sticking to the text, is the directorship a reason for the grant of this 2007 option? Without that directorship, on this financial package, in this case, there would be no equity milestone, etc., etc. Please, if I have not a minute, 10 seconds. That's my reply.
Thank you very much. Well, the court is very grateful to both counsel for their submissions in this interesting case, and also to those who have assisted counsel who've spoken in the preparation of their submissions, and to those behind them who have assisted in the preparation of the papers. The court will deliberate on this matter and produce a judgment in due course. The court will now adjourn.